This is ABC News legal analyst Royal Oakes welcoming you to Hinshaw Culbertson's Insurance Law Program, where we discuss insurance and reinsurance issues of interest to industry professionals. Here's your host, the co-chair of Hinshaw's Global Insurance Services Practice Group, Scott Seaman.
Hello, everyone. Thank you for joining us on Insurance Law. I'm Scott Seaman, and on this episode, we will discuss some recent environmental coverage cases and developments in the lead paint coverage litigation. Our guest is Shane Dilworth, the outstanding senior reporter covering the general liability beat for Law 360's Insurance Authority. Thank you, Shane, for joining us.
Thanks for having me, Scott.
I took a look a few weeks ago at your fine article on key decisions in 2022, and you highlighted a couple of interesting environmental cases. The first one involves a ruling by the Illinois Appellate Court close to my home in Illinois Union versus Medline. It involves ETO emissions from a Medline facility. What are the takeaways from that case?
I think the highlights of this case are the appeals court's finding that the Chubb unit had no duty to defend Medline after finding that emissions from the company's Waukegan, Illinois facility occurred prior to a September 2008 retroactive date in the policy. Another big takeaway is that the panel also decided that the emissions were continuous, contrary to the medical equipment maker's argument that the discharges, including so-called fugitive emissions, were individual in nature. As a result, Illinois Union had no duty to defend Medline in 19 personal injury suits brought by nearby residents over their exposure to the sterilizing agent.
Interesting ruling. I think they got the ruling correct. There was also a little hanky-panky with the underlying plaintiffs and the policyholder attempting to collude a little bit and alter allegations in the complaint, just showing you how easy it is to for courts to get caught up in that, but that did not happen here, which I thought was also a good sort of underlying development in the case. Another case that or actually a pair of cases you discussed were Sterigenics and Griffin Foods, Northern District of Illinois. So we're staying in Illinois from August of 22. What's the significance of these cases?
Well, unlike the ruling in Illinois Union, the judge presiding over these cases found that the insurers had a duty to defend their policyholders against personal injury suits brought over ethylene oxide exposure. In August, U.S. District Judge Mary M. Rowland ordered National Union to defend Sterigenics and Griffin Foods International against a putative class action after finding that the plaintiffs sufficiently alleged that their exposure to ethylene oxide caused covered bodily injuries.
Yeah, once again, the significance of pleadings. Decision comes out the other way. But you do have us leave the great land of Lincoln for New York, involving an environmental coverage case called ConMed Corp from the Northern District of New York, right?
That's right, Scott. I selected this case based on the judge's finding that a pollution exclusion in a policy issued by the Chubb unit to ConMed was inapplicable. Federal Insurance Company also tried to convince U.S. District Judge May DiAgostino that an indemnification agreement between ConMed and Sterigenics did not require the carrier to provide a defense. According to Federal, ConMed's indemnification of Sterigenics was voluntary because it did not have to defend actions arising out of negligence. The insurer also contended that a reciprocal indemnification provision relieved the policyholder of its obligation to indemnify Sterigenics because ConMed was not accused of negligence in the underlying suit. According to the company's contract, the provision states that ConMed will defend and indemnify Sterigenics for damages caused by its negligence, unless those damages stem from Sterigenics' negligent acts. So basically, we had rulings favoring each side of the aisle.
Yeah, a split the baby type of decision. So a good summary of some recent environmental cases of interest. You also took a look at a trilogy of lead paint coverage, lead paint abatement coverage cases, 3 cases that stem from the same underlying judgment, but involve 3 different coverage actions and 3 different appellate court decisions. If you would just set the stage for us with a brief description of the underlying case.
Absolutely, Scott. It's kind of crazy to think it's been 20 years since this all really began, because it started in 2000 when a number of California counties and cities sued makers of lead paint, accusing them of knowing about the risks of the product and seeking the creation of a fund to help clean up homes. The trial court judge found in favor of the cities and counties and ordered the companies in 2015 to pay $1.15 billion into an abatement fund. That amount was later reduced to $401 million, and the companies eventually reached a settlement in 2019 to pay $305 million. The companies then turned to their insurers for coverage of their portions of the settlement amount.
And of course, as you point out, the underlying litigation going on for more than 20 years and the several years involving the subsequent declaratory judgment actions. So let's see what happened on the coverage side, first with the ruling by the Ohio Supreme Court involving one of the three underlying manufacturers, Sherwin-Williams.
In September, an Ohio appeals court overturned a trial judge's ruling that Sherwin-Williams insurers did not have to cover its portion of the settlement amount. The panel disagreed with the lower court judge that the damages are not covered since the money is not intended to compensate individuals for physical injuries.
So we got a policyholder win in Ohio, and then another of the three companies, NL Industries, they prevailed before the New York Intermediate Appellate Court. What happened there?
That's right, Scott. In March, a New York panel said some of NL Industries insurers are on the hook for covering the settlement amount. The panel concluded that the company did not act knowingly or intentionally when promoting lead-based paint, and that coverage was triggered under policies that did not have an exclusion for expected or intended losses.
So now we go all the way west to California, and that case involved ConAgra. What did the California Court of Appeals do?
ConAgra did not fare well in its quest for coverage due to a unique statute in California law that prohibits insurers from defending or indemnifying a policyholder accused of willful misconduct. In April, a California appeals court said that more than 50 of ConAgra's insurers did not have to cover the settlement amount pursuant to California Insurance Code Section 533. Even though ConAgra never made lead-based paint, the panel said it assumed the liabilities of W.P. Fuller & Company, a company that ConAgra acquired through a series of mergers. The appeals court ruled that Fuller's knowledge of the hazards of lead paint was enough to relieve the carriers of coverage under Section 533. The California Supreme Court later denied review of that ruling.
So that case is now final. That's a win for the insurers, 1 out of 3 in the insurers camp, arising out of this, what initially was over $1 billion judgment. And so California may be not doing so well in terms of being very liberal in the underlying tort of public nuisance, but on the coverage issue, right on point based on Section 533. And some would argue that the same principles that underline Section 533 of the California Insurance Code ought to have resulted in victories for the insurers in those other cases. Our thanks once again to Law 360 Insurance Authority Senior Reporter Shane Dilworth. To keep apprised of important case rulings and developments in insurance coverage for environmental claims and other claims, lead claims, you name it, make sure you follow Shane at Law 360 and follow us, of course, at Hinshaw Insurance Law. We hope you'll join us for the next episode of Insurance Law.
The information on our insurance law program is provided for general information purposes only. Nothing stated on the program constitutes legal advice or creates an attorney-client relationship. You should consult directly with an attorney of your choosing if you'd like to obtain any advice with respect to any claim, case, or matter. Any views expressed are those of the guests and are not necessarily the views of Hinshaw Culbertson or any of its clients. For information on past and upcoming programs, visit the Insurance and Reinsurance page on www.hinshawlaw.com and click on Multimedia.